Welcome to the Polity Prelims program. This is Union and its territory. My name is Atish Mathur. This is my Telegram channel, CSE Paper 2 Atish. You can directly search for this Telegram channel on your applications and you would be able to join the same directly. Alternatively, you can always paste this link in your mobile browsers and you would be directed to the right Telegram channel. Let's begin. The core contents of this video include a constitutional layout and key provisions with respect to union and territory. Second, the types and processes of territorial changes. Third, a brief and a very cursory look at some important committees which were historically important in shaping India as it is today. And lastly, summarizing the kind of questions that can be asked with respect to the prelims exam. Let's dive straight in. The constitutional layout and key concepts. The very first part of the Constitution, under Articles 1 till 4, supported by Schedule 1, which contains the list of articles and their areas, is what are called the key provisions with respect to union and territory. Now, you do not need to memorize the article numbers as such, but yes, you must know what is contained in Schedule 1. This includes a list of states and their areas. This is very important because this will help you solve a lot of conceptual questions later on. As you know, India today has 28 states and 9 union territories. In addition to this, in these states and union territories, there are special treatment or special provisions mentioned in Part 21, the 5th and the 6th schedules for better administration and governance as well as the welfare of people in these areas. This chapter, called Union and Territory, does not deal with special treatment. It primarily deals with the geographical, spatial, or the territorial changes that are made to the entire country called India. This particular chapter is also a classic example of the unitary form of federalism, where the center is always stronger than the states. And through the course of this, we will understand in many forms how the center plays a supervisory or a higher role with respect to states when it comes to union and territory. In fact, right at the very outset, it is very clear to mention that the states play a negligible role when it comes to union and territory. Now, it's also very important to understand that this particular portion is rarely asked in the prelims. But the recent reorganization of Jammu and Kashmir has put this particular chapter in absolute focus. Right? So let's get ahead. Broadly speaking, there are two types of territorial changes. One, external, or with respect to another country. This means that the country or the territory of India is going to change because of some form of territorial kind of an interaction with another country. That is why we call this as the first type, external or with respect to another country, because of something that India will do with another country. This could mean a transfer of land, this could mean an exchange of land, it could mean 10 other things. But this primarily affects the territory of India because of something that India transacts with another country. And the second type is the internal or the reorganization of states. This could mean redrawing a state boundary, naming a state, merging states into one, or bifurcation of states into two. So, predominantly speaking, there are two kinds of territorial changes: external, or with respect to another country, or internal, which is reorganization of states. So, let's look at the first part. When we talk about external changes with respect to another country, To simplify it, there are broadly of three categories. One, ceding, or in a case where there is no boundary dispute. This very simply means the land clearly belongs to India and the land clearly belongs to another country X. Now, there is going to be a change of land ownership. This could mean India giving land. This could also mean India receiving land. This could also mean India gifting land. Now, this broadly is called ceding the territory. Ceding only happens when there is no boundary dispute. Now, how do you know there is no boundary dispute? This is when the government of India officially recognizes that this is a boundary dispute. If it does not, no matter what the world says, it is not a boundary dispute. For example, Kashmir. The official Indian government policy is that Kashmir belongs to India. So, as far as India is concerned, Kashmir is not a boundary dispute. Is this okay? The second is settling a boundary dispute. In case India recognizes that there is a boundary dispute between India and another country, and India is trying to resolve that boundary dispute. And third, there could be a possibility of a piece of land that does not belong to anyone, and multiple countries are staking claim on this. So, solving this, settling this, or settling unclaimed areas is the third kind of an external change. Let's begin with the first. In the situation that there is no boundary dispute, which basically means India is ceding territory, India is giving territory. In the case of strictly no boundary dispute, when you are effecting such a change, that change will always be a constitutional amendment under Article 368. This is non-negotiable. And when we say constitutional amendment under Article 368, this means special majority without state ratification. Okay, so this also reflects, as I said before, the unitary form of federalism. So, a constitutional amendment under Article 368 without state ratification. A classic example of this is the recently concluded Indo Bangladesh Land Boundary Agreement, which effectively gave rise to the 100th Constitutional Amendment. So, the 100th Constitutional Amendment is an amendment under Article 368 without state ratification because India had given land to Bangladesh. Now, there was no boundary dispute. It was very clear that the land belonged to us and the land belonged to them. So, it was essentially solving what was, or in a very simple way, making land ownership or land rights easy. So, the land boundary agreement is nothing but a constitutional amendment under Article 368. Now, you must be wondering, why have I written the land boundary agreement here? So, don't worry, I'll come back to this and I'll explain why. Okay? Another example of this is the first Berubari Union case. Contrary to popular belief, there are actually two Berubari Union cases. In the first case, this was a transfer of territory which belonged to India and was transferred to, back in the day, Pakistan. This happened in 1960. Just for your reference, this means the territory officially belonged to India. We owned the territory and we were ceding the territory. So that is why this was also a constitutional amendment under Article 368. Coming to the second one, settling a boundary dispute. As I said before, for something to be a boundary dispute, the government must recognize it to be a boundary dispute. If the government does not, it's not a boundary dispute. Now, The Constitution was silent on this. Now, if the Constitution is silent on this, it is the job of the Supreme Court to interpret and show us direction and light. And that's what the Supreme Court did. In a lesser known but a very important, a very, very important Supreme Court judgment called Magan Bhai Ishwar Bhai Patel versus Union of India in 1969, the Supreme Court said, if you are settling a boundary dispute, then you don't need any law to be passed. A simple executive order by the executive is more than enough. Now you'd be wondering what happened. So let me walk you down through the lanes of history. This is actually very interesting. The Magan Bhai Ishwar Bhai Patel case actually relates to the area of Kutch. Now, in 1965, both India and Pakistan had agreed that there were certain parts in Kutch which were not clear in terms of ownership. So they both agreed to set up a tribunal, and that tribunal will tell us who will take those specific lands in Kutch. Now, the tribunal awarded a part of those lands in Kutch to Pakistan. And the tribunal said, we've decided that those certain parts of Kutch will go to Pakistan, and both the Indian government and the Pakistani government will release letters to each other stating that they agree and they understand and fully comply with the order of the tribunal. Now, Magan Bhai was very upset because he was a businessman in that area and he was worried of his business getting affected because the land would have been given away, because he was someone who lived on one of these areas. So he said, my Article 19 is getting affected. So under 32, he went to the Supreme Court. Now, the Supreme Court found this as an amazing opportunity to look into a larger issue, which was settling a boundary dispute. Now, the Supreme Court very clearly said that the Constitution of India is silent on this. No doubt, we have something called Article 253, where in case you want to implement an international document or a treaty, the Parliament can do so. But what if the treaty or the order or the international document asks you to release letters? It tells you how to implement it. Because the Constitution is specifically silent on something like this, the Supreme Court said it lies in the executive domain. And that is how we come to the conclusion that yes, in case of settling a boundary dispute, an executive order is more than enough. Which now brings me to the third part, settling unclaimed areas. Now, settling unclaimed areas is also done through an executive order. This is also understood as an implied outcome of this judgment. Because the Constitution is silent on this, it could be understood that yes, we could do this through an executive order. Let me give you some context, and you will also understand why I wrote the Indo-Bangladesh Land Boundary Agreement here as well. If it was letters to the Kutch Tribunal issue, in the Indo-Bangladesh Land Boundary Agreement, we set up something called the 2011 Protocol. This had clearly demarcated what needed to be done, and it had clearly demarcated the undemarcated areas. So to put it into context, the Indo-Bangladesh Land Boundary Agreement actually has three things. One, enclaves. Enclaves is an Indian territory surrounded by a Bangladeshi territory, surrounded by an Indian territory, surrounded by a Bangladeshi territory. Now here, it's clearly established this is an Indian territory, this is a Bangladeshi territory, this is an Indian territory, this is a Bangladeshi territory. This is called a multiple order enclave, and the only where in the world where you would find a multiple order enclave is India and Bangladesh. So clearly, this particular issue was a case of ceding. Second was adverse possessions. Now, adverse possessions means if this is the boundary, this is India, and this is Bangladesh. Some of us crossed the boundary and came here, and some of them crossed the boundary and came here. But we clearly knew whose land it was. So, again, no boundary dispute. You had to arrange and give up these lands so that there is more welfare in the region. So, for enclaves and adverse possessions, you required a constitutional amendment under 368. But to settle undemarcated areas, a simple executive order was enough. This means the 100th constitutional amendment only got into force two out of the three things that the Indo-Bangladesh Land Boundary Agreement spoke of. And the third, which is an undemarcated area, was actually done through an executive order. And this is as simple as it gets. Three kinds of external changes: ceding, which is the same thing as resolving or trying to give up land, and there is no boundary dispute to resolve. Second, settling a boundary dispute. Third, settling unclaimed areas. Let's move to the next one. Internal or reorganization of states. This is as simple as it gets. This could mean changing the name of a state, adding an area, subtracting an area, combining two states, bifurcating two states. It's essentially an internal reorganization of states, and the process is very simple. The president starts it. Now, the president first refers the bill to the state legislatures, whichever are concerned to that respective division. The state legislatures can inform the president their views. Whatever they say is not binding on the president, and a reasonable time frame has to be followed. Even not, it doesn't matter. After this, the president refers this to the parliament. The parliament now has the bill in front of them. Please understand this. The constitution clearly says the parliament has the power to do this. All internal changes are ordinary bills which are passed through simple majority. This is why you would have heard of something called the Andhra Pradesh Reorganization Bill, or very recently the J&K Reorganization Bill. So how did the J&K Reorganization Bill happen? When Article 370 was abrogated through a presidential order, then you could change the nature of J&K, and then the parliament passed the J&K Reorganization Act of 2019 after the presidential order on Article 370. This was done through an ordinary bill through an ordinary way through a simple majority. Now remember, I told you, Schedule 1 of the Constitution gives you the name of the state and or the areas included. So whether you're bifurcating Andhra Pradesh into Andhra Pradesh and Telangana, or you're redistributing land in J&K and you're converting it into, say, J&K as one union territory with legislative assembly and Ladakh as the second union territory without a legislative assembly, in such a case you would have to make those changes in Schedule 1. So yes, you can change Schedule 1 through an ordinary bill with a simple majority. Now you would be wondering, sir, is this possible? Can we change something in the Constitution through an ordinary bill? Yes, of course. For example, last year in 2019, you would have heard of multiple such instances. It is very possible for you to change the Constitution, very specifically Schedule 1, through an ordinary bill. And this is why it's also called these kind of changes as outside Article 368. Which brings me to a very interesting question. What about names of places? Very specifically, capitals or cities. For example, Bangalore to Bangalore, Madras to Chennai. How do those things happen? The answer is through a simple executive order. This could be actually done by the states because Schedule 1 does not mention the names of the cities or the names of the capitals. It just mentions state name and areas. So if you're changing the name of a state, then yes, you require an ordinary bill with a simple majority, which also changes Schedule 1. But if you're changing the name of a capital, you don't require any law as such. And this is how states are reorganized in the country. Clear? It's that simple. Simple enough. And this covers the key elements of the substantive discussion on legal provisions. Let's look at some important committees. Now, under no circumstances would you be asked the technical details of these committees, but just to cover base, let's look at what they are. The first was the Dhar Committee, the first linguistic commission, which had recommended geographically, financially, and administratively to set up states. The JVP Committee, which is Jawaharlal Nehru, Vallabhbhai Patel, and Potramaya, which is in 1948 again, they recommended security and finance as the grounds. Then finally came the Faiz Ali Commission, the Third Linguistic Provinces Commission in 1953, which said we should do all of those things plus language and culture. And that's how the State Reorganization Act of 1956 happened. Dominantly on language and culture, but India, states are also reorganized or divided or set up on financial reasons, on administrative reasons, on geographical reasons, on security related reasons, on language as well as cultural reasons. This has been the broad idea. Now, after this, you've had specific reorganization acts. As I said before, the Andhra Pradesh Reorganization Act, the J&K Reorganization Act, Goa Reorganization Act, and so on and so forth, which also includes, for example, the Uttar Pradesh Reorganization Act, which carved Uttarakhand out of Uttar Pradesh. And that, boys and girls, is all you need to know. Finally, summarizing the questions that can be asked. What you really need to know for the prelims is the types of changes and the processes of changes. If you're able to remember the two basic slides that I've done for you in the simplest form, you would not need anything else for as far as union and territory is concerned. Thank you so much for your time. Do let me know in the comments box as to how you liked the video and any suggestions or feedback that you'd like me to incorporate in the next ones. Until then, good luck, happy studying. Thank you again for your time.